It was supposed to be an ordinary morning on my ranch, the kind where the dew still clings to the grass and the creek hums softly beneath the bridge I'd come to cherish over the years. That old wooden bridge wasn't just a structure connecting one side of my land to the other. It was a piece of my family's story, a path my children ran across in their youth, a quiet place I'd stand with a cup of coffee and watch the sun spill gold across the water. But on this particular morning, as I stepped out with my boots crunching over the gravel driveway, I noticed something off in the distance. At first, I thought it was a trick of the light. Maybe the angle of the sun was hiding the bridge's silhouette. Maybe the mist rising from the creek was playing games with my eyes. I squinted, adjusted my hat, and walked a little faster. Then my heart sank. The bridge was gone. Not damaged, not under repair, completely gone. All that remained was churned up mud on either bank, piles of broken timber, and tire tracks leading back toward the main road. My mind struggled to process it. Who would tear down a private bridge on private land? My property was clearly marked. There were fences, there were signs, there were gates. Anyone coming in would know this was not some communal park, but a working ranch that had been in my family for decades. I stood there in disbelief, staring at the torn-up ground, the empty stretch where my bridge had been, feeling a dull ache start to build behind my eyes. I followed the muddy tracks with slow steps, my mind racing through every possible explanation. Maybe it was vandals. Maybe the county made a mistake. Maybe someone thought they were doing flood prevention work on behalf of the state. But even as I considered these, none of them made sense. It wasn't until I drove up to the small wooden sign posted near my front gate that the full weight of it hit me. Nailed right beneath my ranch's name was a bright white notice from the local homeowners association. The paper was laminated against the weather, stamped with their emblem, and full of dense language citing community standards, unauthorized structures, and aesthetic noncompliance. My pulse pounded in my ears as I read the lines over and over. The HOA, an entity that governed a subdivision several miles down the road, had apparently decided that my bridge was an eyesore. They claimed it didn't meet their so-called architectural guidelines. As if my family's bridge, built long before their subdivision even existed, was subject to their petty rules about symmetry and paint colors. I couldn't even wrap my head around it. My ranch sat on its own parcel, far removed from their cookie-cutter homes and neatly trimmed lawns. We weren't under any covenant. I never signed their agreements. They had absolutely no jurisdiction here. And yet, somehow, they took it upon themselves to march onto my land with heavy equipment and demolish a structure that was legally and rightfully mine. The audacity of it struck me like a hammer. Who did these people think they were? Did they believe their little board meetings and monthly newsletters gave them the authority to override private property rights? I paced the edge of the creek, my boots sinking into damp earth, breathing hard as frustration twisted into something deeper, a cold, calculating anger. I could still see remnants of my bridge, a cracked plank wedged under some brush, rusted nails scattered like confetti across the bank. This wasn't just about wood and nails. It was about principle, about the basic respect for boundaries and ownership that holds any civil society together. The more I thought about it, the more glaring it became that this wasn't a misunderstanding or an accident. They had deliberately trespassed, decided my land fell under their control, and carried out destruction without so much as a courtesy call. And as I stood there, staring at the wreckage, I knew this was only the beginning of a much larger reckoning. The shock of finding my bridge reduced to splinters slowly gave way to a sharper awareness of just how serious the situation truly was. At first, the outrage centered on the blatant nerve of the HOA, their gall to tear down something that didn't belong to them. But the more I studied what had happened, walking the scarred earth where my bridge once stood, the clearer it became that this was far more than a neighborly dispute or a misunderstanding over some bylaws. This was a direct violation of property rights, carried out with heavy machinery and total disregard for any legal process. It wasn't just a question of etiquette or neighborly courtesy. It was trespass, plain and simple. A forced intrusion onto my land without my consent, resulting in the destruction of a structure that held both personal and financial value. And this wasn't just any patch of pasture or decorative garden bridge. My ranch spans land that is subject to federal conservation protections, carefully documented through easements and stewardship agreements that ensure certain natural. Every broken beam from my bridge represented an infraction that wasn't just civil in nature, but potentially criminal under the layers of overlapping federal laws designed to keep local authorities from overstepping their bounds on private land. I spent that afternoon meticulously photographing the site. I documented tire impressions, fragments of wood, even little tufts of grass that had been ripped up and left to die under piles of displaced earth. I gathered every scrap of evidence, knowing this situation had escalated far beyond a private squabble. It had become a matter of jurisdiction, and the HOA had blundered straight into a realm they clearly didn't understand. It was almost surreal to stand there and think about how a handful of individuals, elected by a small suburban enclave, could presume to override rights that were upheld by federal agencies. They seemed to believe that their local association's architectural guidelines, meant for matching mailboxes and uniform hedge heights, somehow gave them dominion over a ranch that predates their subdivision by decades. Their notice claimed the bridge violated community aesthetics, a phrase so absurd it would have been laughable if not for the real damage left behind. They cited provisions that only applied within the narrow boundaries of their own residential streets. Never mind that my property was miles from the nearest HOA governed lot. It was as if they imagined their sphere of influence could stretch out infinitely past the edges of their manicured lawns and decorative gates, sweeping up land that had no legal ties to them at all. But their arrogance did more than annoy me. It opened them up to serious exposure. Because under federal property protection statutes, unauthorized entry onto such land, especially when accompanied by willful destruction, isn't just a question of paying for damages. It's grounds for substantial penalties, investigations, and enforcement actions that are handled by agencies with powers that dwarf those of any homeowners association. As I continued my survey of the damage, jotting notes and time-stamping photographs, I realized the HOA hadn't merely committed a social misstep. They had violated my federally recognized property rights in a manner that triggered protections most people never have to think about. And whether they acted out of ignorance, arrogance, or some misguided sense of authority, it wouldn't shield them from the repercussions of what they had done. Each crushed blade of grass, each splintered board, each rut in the soil was more than just evidence of disrespect. It was evidence of legal liability that pointed straight back to their doorstep. Standing there on the muddy bank of my creek, staring at the vacant space where my bridge once stretched so proudly, I began to feel a subtle but powerful shift inside me. The violation was undeniable. The evidence was everywhere: torn up ground, shattered planks, the faint smell of diesel still hanging in the morning air. But more than that, there was the raw nerve of it, the way this HOA had presumed to exercise power over land they had absolutely no claim to. In that moment, all the years I'd spent upholding the law from behind a federal bench rose up in me with a clarity sharper than any anger. Because this wasn't just about my personal grievance. This was about the foundational principles of jurisdiction, property rights, and due process that I had spent my entire career defending. In my position as a federal judge, I've presided over countless disputes, boundary disagreements, land encroachments, even complicated questions of overlapping state and federal regulations. I know the weight of the law, know how meticulously it's supposed to protect the lines that separate one entity's authority from another's. And as I stood on my own land, boots pressed into the churned earth, I recognized that the HOA's decision to unilaterally demolish my bridge didn't just test the boundaries of neighborly courtesy. It flew in the face of the very framework of governance that prevents chaos. They had ignored the requirements of notice and consent, sidestepped even the basic decency of a conversation, and instead took direct action on private property as though their small local association was an all-powerful agency. That level of hubris wasn't merely misguided. It was a direct affront to the careful checks and balances that keep power in this country from being abused. As someone entrusted with enforcing, the realization settled over me like a calm, cold certainty. This wasn't going to be a fruitless shouting match across a conference table or a barrage of angry letters tacked onto community bulletin boards. This was going to be a matter of federal jurisdiction, with all the weight that implied. The HOA board had chosen to ignore the clear limits of their reach, and in doing so, they had trampled over statutes that I had spent my career upholding. They had effectively invited federal scrutiny into their backyard, an arena they were entirely unprepared to navigate. As I made my way back toward the ranch house, mentally cataloging each legal avenue now open to me, I thought of all the homeowners they must have bullied over the years, people who didn't have the resources or the knowledge to push back. I thought of the elderly couple I'd once heard about, who had been threatened with liens over a garden shed that was 3 feet too wide, or the young family forced to rip out mature trees because they hadn't filed the right paperwork with the design committee. Those stories always bothered me, the way a small local power structure could twist rules meant for community upkeep into tools of intimidation. Now it was clear that unchecked arrogance had finally driven them to step far beyond local fences and right into a federal matter. And standing there, aware of every protection my position and the law afforded, I knew with absolute confidence that this time, they wouldn't be the ones dictating terms. Once I had gathered my evidence and let the full gravity of the situation settle in, I wasted no time in taking the matter exactly where it belonged, into formal federal legal proceedings. My years on the bench had given me an intimate understanding of how these processes unfolded, how documentation, precedent, and statutory protections work together to build an unassailable case. But this time, it was personal. I wasn't wearing the robe or sitting behind a bench. I was the aggrieved property owner whose rights had been violated in the most blatant, careless way. I began by drafting a detailed report of the incident, supported by photographs from every conceivable angle, sworn statement from my ranch hands who witnessed the crews rolling in without so much as knocking on our door, and certified copies of my property records that clearly placed the land outside any HOA jurisdiction. I prepared everything meticulously, knowing that in matters of law, thoroughness is often the difference between success and frustration. The initial filings went out not just to the local circuit, but directly to the appropriate federal agencies responsible for overseeing conservation easements and private land encroachments. Because of the federal protections tied to my property, the HOA hadn't simply crossed a neighborly boundary. They had potentially violated federal environmental regulations and property rights statutes that trigger automatic reviews. I knew these agencies took such reports seriously, not only because of the environmental stewardship implications, but because overstepping private land rights sets dangerous precedents. Within days, formal letters were dispatched to the HOA's registered address, informing them of the investigation and ordering a freeze on any further activities near my property pending the outcome. I can only imagine the reaction inside their boardroom when those letters arrived. These were people accustomed to dealing with minor local complaints, grass heights, seasonal decorations, perhaps the odd noise violation. Suddenly, they were receiving notices bearing federal seals, citing statutes most of them had probably never even heard of, much less understood. It must have struck them like a lightning bolt, this realization that they were now under the microscope of agencies with far-reaching enforcement powers. My attorneys followed up with a civil complaint seeking not only to recoup the costs of rebuilding my bridge, but also damages for the trespass itself and the harm done to the protected ecosystem along the creek. Under federal law, damages aren't limited to simple replacement costs when protected land is involved. There are multipliers and punitive assessments designed to ensure violators think twice before ever making the same mistake again. I wanted this to serve as more than just personal restitution. I wanted it to stand as a clear message to anyone who believed their small-scale governance could somehow override well-established property rights. Throughout the process, I remained very deliberate. I didn't give press interviews or stage dramatic confrontations at HOA meetings. I simply let the system I had sworn to uphold work as it was meant to. Meanwhile, the HOA's own insurance providers and legal representatives were being forced to grapple with the staggering consequences of what their client had done. It wasn't long before I heard, through the channels that always seemed to whisper news back to the parties involved, that panic was spreading among the board members. They had believed themselves to be powerful. Signatures on ballots, control over neighborhood dues, the ability to issue fines and enforce cosmetic uniformity. But confronted with actual federal jurisdiction, with legal language that cited penalties they couldn't shrug off with a vote or a committee ruling, their confidence apparently began to evaporate. Depositions were scheduled, records subpoenaed, site surveys conducted by government specialists who care not at all for local politics. Each new layer of the investigation peeled back more of their careless assumptions and laid them bare under the bright light of legal scrutiny. I had no doubt some of them had acted out of ignorance rather than malice, but ignorance is no defense under these circumstances. The law exists to protect everyone equally, regardless of whether those in minor positions of power bother to learn its limits. As the proceedings built momentum, it became increasingly clear this case would reshape not only how this HOA conducted itself in the future, but possibly influence policies in neighboring communities who might otherwise have believed they too could ignore clear jurisdictional lines. As the case advanced, the discovery process began to reveal details that painted a far darker picture of the HOA than I had originally imagined. What had started for me as a simple property destruction issue quickly unfolded into something far more troubling. Through the subpoenas and document production demands, my attorneys obtained internal HOA communications, meeting minutes, and financial statements that gave us a window into their true operations. What we found was a pattern of overreach and misuse of community resources that went far beyond my bridge. Their emails showed a casual arrogance in discussing properties that weren't even within their mapped boundaries. There were repeated mentions of cleaning up the view from the subdivision by targeting structures on neighboring lands. In one thread, a board member joked about how easy it was to pressure less informed property owners into compliance simply by sending intimidating letters on official-looking letterhead. It was clear they had come to view themselves as a kind of petty ruling council, empowered to shape not just their streets, but anything they could see from their sidewalks. There was even a note that suggested they knew my land was technically outside their jurisdiction, but believed taking decisive action would prevent eyesores from affecting property values, as if that alone justified ignoring clear legal lines. When it came to the financial records, the situation grew even more concerning. My legal team uncovered questionable expenses paid out of HOA dues, invoices for contractors that weren't properly documented, checks written for special projects without board-wide approval, and reimbursements to certain members that had no receipts attached. Among these were payments tied to the demolition crew that tore down my bridge. Instead of competitive bids or properly recorded contracts, there were vague authorizations rubber-stamped in hastily called meetings, sometimes with less than a quorum present. It became evident they had bypassed even their own procedural requirements to push through this so-called improvement project. Residents who paid their monthly dues had every reason to believe those funds were going to maintain shared amenities, the clubhouse, the community pool, the landscaping within the actual subdivision. Instead, their money was funneled into ventures that had no legal grounding and no benefit to the people footing the bill. As these revelations stacked up, the HOA's risk profile ballooned. They were now exposed not only to the damages I sought under federal property and environmental statutes, but also to potential claims from their own residents for mismanagement of community funds. More than a few homeowners came forward quietly through their own counsel, expressing frustration at years of unexplained assessments and opaque budgeting. It appeared my case had opened a door they'd long been too intimidated to push against. Meanwhile, the depositions of board members often swung between arrogance and panic. Some insisted they had every right to ensure the visual integrity of the area, while others tried to deflect blame by saying they simply signed off on recommendations without understanding the implications. A few became visibly uncomfortable when confronted with their own emails boasting about pressuring nearby landowners or bragging about sidestepping permit processes. Watching these proceedings unfold, I felt less personal vindication than a deeper concern for how easily a small group of people could consolidate unchecked authority in a community, simply because no one had stood up to draw a line. The more layers we peeled back, the clearer it became that what happened to my bridge was not some isolated act of misplaced enthusiasm. It was part of a culture of casual dominance, where the HOA leadership routinely pushed past the boundaries of their actual power, emboldened by years without real challenge. And while the specifics of my case rested on federal property law, the broader impact was shaping into something that might finally check the ambitions of those who confused small governance with unlimited control. Throughout it all, I remained deliberate in my approach. I refused to let the proceedings devolve into a personal vendetta or emotional spectacle. My aim was simply to ensure the law was upheld, to see that the people who had taken it upon themselves to rewrite the rules of property ownership were held fully accountable. In doing so, it became increasingly clear that this case was growing into something larger than either my ranch or my bridge, something that would stand as a warning to any similar groups who believed they could enforce personal preferences through intimidation and misuse of collective power. By the time the hearings drew into their final stages, the landscape of the entire situation had transformed dramatically from where it began. What once was just my quiet ranch with its old wooden bridge had become the centerpiece of a legal battle that reached well beyond county lines, drawing the attention of federal regulators, neighboring communities, and even property rights advocates who have been waiting for a case like this to highlight how unchecked local power could spiral. As the process advanced, the weight of the evidence piled against the HOA became undeniable, documented in painstaking detail through statements, photographs, internal records, and expert reports. Each day seemed to peel back another layer of negligence or outright disregard for the law, building a narrative that no carefully worded HOA newsletter could ever undo. It wasn't just about their decision to trespass or the brazen act of destroying my bridge without permission. It was about the broader misuse of authority and how easily a small group of individuals, emboldened by years of little opposition, felt they could dictate what happened even on land that was never theirs to govern. During the proceedings, my legal team presented testimony from environmental specialists who documented the damage to federally protected creek banks caused by heavy machinery. They detailed how root systems had been ripped up, how sediment had flowed downstream, disrupting fish habitats, how native plants carefully monitored under conservation easements were flattened in hours by equipment brought in on an unauthorized whim. Each of these findings carried its own set of federal implications that were difficult, if not impossible, for the HOA's representatives to explain away. I watched as the same board members who once acted with smug certainty were forced to sit under oath, confronted with direct questions about why they believed they had jurisdiction over my land, who exactly approved the expenditure of funds to hire demolition crews, and whether many were supportive, apologetic even, saying they had no idea the extent of what their board had been doing in their name. A few shared stories of how they, too, had felt coerced by threatening notices or penalties for harmless issues like having the wrong style of patio furniture or planting flowers outside the approved color palette. It became painfully obvious that my bridge wasn't the first casualty of this board's overreach, just the most dramatic and legally consequential. That revelation drove home the importance of seeing this through not only for my sake, but for everyone who had been steamrolled by small local tyrannies masked as community standards. In the end, the penalties imposed were substantial. The combination of civil damages, restoration requirements under federal oversight, and fines tied to specific environmental violations amounted to a figure that would strain any small HOA budget. Their insurance providers balked at the scale, leading to special assessments that outraged many homeowners who suddenly realized they were financially tied to the reckless decisions of a few power-hungry board members. On top of that, compliance orders required professional restoration crews to rebuild the creek banks and replace damaged habitats under federal supervision, all at the HOA's expense. As for my bridge, I ensured it was reconstructed using designs approved by federal conservation agents, with added protections in place to guarantee that no unauthorized hands could tamper with it again. Watching the new timbers go up, anchored securely over the restored banks, I felt a quiet satisfaction not born of revenge, but of rightful order being restored. Through all of this, I remained keenly aware that my unique position as a federal judge gave me resources, knowledge, and protections that many ordinary landowners would never have. That was exactly why it mattered so deeply to see this case carried through to its fullest legal extent, so it could stand as a clear, documented precedent for any future overreaches. The sight of that completed bridge, set against the backdrop of my wide fields and flowing creek, became more than just a return to what I had lost. It stood as a marker of the limits of power, a tangible reminder that private property rights, once threatened, could still find robust defense under the rule of law.